He is one of only a handful of attorneys in private practice today who was on the enforcement staff at both the SEC and the NASD. At the SEC, Brian was Senior Enforcement Counsel, and at NASD, he was Deputy Chief Counsel of Enforcement. He won the Burton Award for Legal Achievement for his article entitled "The House That the Regulators Built, an Analysis of Whether Respondents Should Litigate Against NASD." He also recently gained some attention for an article called "The Girl with the SEC/FINRA Tattoo, Disciplinary Actions Taken Against Chief Compliance Officers." Today, Brian will speak about his firm's industry studies and whether FINRA or the SEC have a home court advantage when broker-dealers and reps take on the regulators and defend themselves in litigation proceedings. Brian Rubin.
Thank you, everybody. To mix movie metaphors a little, we have a Godfather theme going, but also, and now for something completely different. For the most part today, we've been talking about FINRA arbitrations, and now we'll be talking about disciplinary actions, so actions brought by FINRA or the SEC against broker-dealers or registered reps, where they can fine or suspend or bar or order the retention of independent consultant or order restitution. And what we'll do is we'll give an overview of FINRA and the SEC generally, and then look at the life cycle of enforcement proceedings. And we've done a couple of analyses every year. One is looking at FINRA sanctions to see what kind of trends there are, and the second is looking at a study of FINRA and SEC enforcement actions to see how often the staff is successful in getting charges, how often respondents are successful, and what kind of sanctions are obtained. Basic background about FINRA, we don't have to go into it, but for the present purposes, one of the things that they do, in addition to having the arbitration forum, is doing examinations, and sometimes the examinations lead to enforcement investigations and disciplinary proceedings, which could either be settled or litigated, and we'll look at some of the statistics dealing with that. Similarly, the SEC also does examinations and investigations, and there is overlapping jurisdiction. So one of the things that we look out for is piling on, where both of the regulators are dealing with the same broker-dealer or same reps on similar issues. The SEC, not only does it have its own disciplinary proceedings, but it also handles appeals of FINRA proceedings, and we'll talk about that. In terms of the number of actions on the FINRA side, generally there's an upward trend, and in the materials that you have in the packet, you'll see some of our analysis looking at the trends and statistics and where the cases are focused. As you can see, there are not a lot of litigated cases. Out of the 1,300 or so cases, last year there were 31 Office of Hearing Officer cases, and that's the trial level. During the review period, we have a study, and we looked at a review period of October 2010 through March of 2012, and during that review period, there were 43 OHO decisions and 25 NAC. The NAC is the National Adjudicatory Council, which is basically the board of FINRA, and from the hearing panel decision, you then go to the NAC for the first level of appeal, you then go to the SEC and the Federal Court of Appeals, and we'll talk about that also. The SEC, during their fiscal year, had about 112 enforcement actions. During the review period, there were 3 ALJ decisions, and we're just talking about administrative cases. The SEC can bring either administrative cases in front of an ALJ, or they can also go to federal court. Usually, with regulated entities, they go the administrative route. With more serious fraud, they'll go into federal court. So again, there's not a lot of litigated cases on the SEC side, but it's important to know how the process works and what the odds are of obtaining some success, so that if you do decide to settle, you can make an informed decision, and maybe you'll make better settlement arguments. We won't go through the life cycle here. This is just sort of teeing it up. It's basic administrative proceedings on both the FINRA and the SEC side. Pre-complaint, finance is a gun, politics is knowing when to pull the trigger. What that relates to is enforcement doing an investigation. They do a fact-finding investigation, and after the investigation, they then make the determination as to whether they have sufficient evidence to file a complaint. You heard about the Wells process and Wells notification. The sources of the investigations, both SEC and Finra, we won't go into this in detail, but they have their normal exams. In addition, they look at arbitrations, they look at U5 filings when reps get terminated. So there are a variety of sources, and their investigations, they request documents and information from firms and from reps. Finra has 8210 power to do that. On the SEC side, they have subpoena authority. If the staff has determined that they think there's a violation, you go through the Wells process. That's a preliminary determination by the staff that they intend to recommend an enforcement proceeding against the proposed respondent. At that point in time, the proposed respondent can decide to settle, they can decide to litigate, or they can put in a Wells submission to try to convince the staff that the staff is incorrect. Sometimes those are successful, sometimes they are somewhat successful. And once the Wells process is done, you then may have the opportunity again to decide whether to settle or whether to litigate. Pre-hearing process, I don't like violence. I'm a businessman. Blood is a big expense. Litigation is a big expense, obviously, too. Hopefully not too much blood is involved. But we'll talk about the pre-hearing process, and it's a simplified proceeding because it is administrative. The regulators file a complaint. It has the factual allegations, the legal authority for the charges, and also general allegations of proposed sanctions. The answer is more like federal court or state court answers as opposed to arbitration answers. Admit, deny, don't know. There may be some fluff language to try to set up the factual scenario, but generally it's not like arbitration answers where you might have pages or paragraphs setting up a scenario or what happened and why it's unfair that the claimants are coming after you. Pre-hearing, there's pre-hearing motions, not a lot of them. Often there's a motion for more definite statement, and there are some other pre-hearing actions. A couple of interesting things is that there is open file discovery, which means that Finra or the SEC has to turn over all of their files to the respondents other than privileged documents. There's no depositions, there's limited discovery. You can ask the staff, either pursuant to 8210 and Finra or getting a subpoena at the SEC to issue a request to other parties, to other broker-dealers, to other reps. There are expert witnesses, exchange of witness lists, pretrial briefs. Then we come to the hearing. I don't need tough guys, I need lawyers. And one of the things that we'll talk about in the statistics is pro se respondents for the past 5 or 7 years have not won a single charge brought against them. So this is a real proceeding. So if you're talking to a rep or an individual and they want to know if they should get an attorney, the answer, unfortunately for them, is yes, you need an attorney to go through this process. It is a real process. It is a rigorous process. The hearing, Finra side. Finra has 3 judge panels. One of them is a hearing officer who is a Finra employee, an experienced attorney, and that person rules on evidentiary motions, pretrial motions, and ultimately they write the decision for the panel. In at least one instance, the hearing officer dissented, so he had to write the dissent in addition to the majority, but that's how it works. The other 2 members of the hearing panel are either current or former industry members, and together the 3 of them sit and make the decision. The SEC, it's an administrative law judge, so like any other administrative proceeding that you'd be involved with. The trial, again, basically an administrative proceeding. Enforcement has an opening, respondent has an opening, enforcement presents its case, and usually that involves calling the respondent. We'll talk about some of those implications in a second. Respondent then goes. Usually there is an active bench. The ALJ or the hearing panel participate actively. There are closing arguments, and then there are usually post-trial briefs. Somewhat unique issues. As I mentioned, in my experience, and I think this is generally the case, the hearing panels in addition to the ALJ, view themselves as having a unique position. They're not just there to listen to the advocates and to hear the arguments and whatever they receive from the advocates, that's it. They are active participants. Usually after somebody testifies, after the direct and cross, they will take over and ask lots and lots of questions. They usually, on the SRO side, the Finra side, self-regulatory organization, they have industry background, they have industry experience, so they know how they do their jobs. So they want to find out how the respondent did his or her job. Another issue is in Finra land, Finra is not a government entity. Therefore, the Fifth Amendment does not apply. And what that means is during an investigation, if FINRA issues an 8210 request for information or for documents or for testimony, even if it deals with personal issues, tax returns, anything else, you have to testify, you have to provide the information, or else you will get kicked out of the industry. Similarly, at the hearing, if a hearing is brought against you and an enforcement wants to call you as a witness, they can, they will, and you have to testify. At these administrative proceedings, hearsay is perfectly permissible and acceptable and commonly used as a form of evidence, so you have to be aware of that. The last issue is on the FINRA side, there are sanction guidelines, which is sort of like the federal sentencing guidelines. They list different substantive areas and recommended sanctions for the substantive areas in addition to general guidelines, and that's something that the hearing panel focuses on. Advantages of litigating or not litigating, pretty standard like any other litigation proceeding. A couple of differences. One is that with SEC and FINRA settlements, you are neither admitting nor denying. You can negotiate the charges, you can negotiate the language of the settlement, but you're neither admitting nor denying, so you may be able to use that to your advantage in civil litigation or in arbitrations, although the other side will say, see, you settled, it has to be an admission of guilt, you must have done it, otherwise you wouldn't have settled, but there is that language, and you can't deny the charges set forth or the facts set forth. Other than that, it's the same basic issues that we would see with any sort of litigation. The statistics, as I said, every year we do a detailed statistical analysis looking at all of the hearing panel decisions on the FINRA side, all of the ALJ decisions, and all of the appeals that go up the line to see what happens. During the review period that we're talking about, charges were dismissed about 14% of the time. As I mentioned before, pro se respondents, 0 success, and that's been the same for 5 or 7 years. Fraud charges are dismissed about 22% of the time, so a lot more than just the general charges overall. The reason is probably because in fraud cases there is a scienter requirement, and unless there's an admission, it's hard for the regulators to prove the bad intent, the intent to deceive, manipulate, or defraud. One of the things that we talk about in the study, and the studies are in the handout, is whether the regulators get the sanctions that they ask for. And about 33% of the time, the respondent will get ordered to pay a lesser fine than the regulators asked for. So there's a question, a legitimate question, I think, as to whether there is a settlement discount. And frankly, I don't think there is. I think once you go into a hearing, they increase the sanction that they're going to ask for, knowing that it's probably going to be less. Those are numbers on average fines. Generally, large firms, legitimate firms, not all the time, but generally they don't end up litigating, and that's one of the reasons why we see the fine level as being relatively low. Suspensions, the staff gets the suspensions 50% of the time. They don't get the suspensions they ask for 50% of the time. When they ask for a bar, a complete bar from the industry, they only get it about 25% of the time. So 75% of the time, the respondents are successful. SEC had a good year and a half during the review period. There were no charges dismissed against the 7 respondents. During the previous 5 or so years that we've done the study, about 10% of the time respondents were successful in getting charges dismissed. So I think this is really an aberration. Reduced fines, about 29%. Historically, the prior time period is about 50%. During this time period, no suspensions were decreased. Historically, it's decreased about 30% of the time. So you have your hearing decision. Next, you have an appeal. Uncle Michael, everyone knows you're the final word. You're like the Supreme Court. And if you look carefully, there's U.S. reports and F-seconds and F-thirds on the bookshelf there, but you have to look carefully. Okay, so appeals. The way it works is the Finra proceeding, as I said before, hearing panel goes up to the NAC, National Adjudicatory Council, goes up to the SEC, then goes up to the Court of Appeals. On the SEC side, it's an ALJ that makes the decision. You then go up to the full commission, the 5 commissioners at the SEC, and then from there you go to the Federal Court of Appeals. On the Finra side, either side can appeal to the NAC, or the NAC can call a case for review. And what that means is if they think the hearing panel made a mistake, or if it's a significant programmatic issue, they'll call it for review to issue a decision. NAC cases, there's an oral argument and briefing. To the SEC, just briefing. On the SEC side, from the ALJ to the SEC, it's also an oral argument and then a briefing. NAC statistics. If you go to the first level of appeal, about 11% of the charges are dismissed, 30% of the sanctions are decreased. On the other hand, 32% of the time the sanctions are increased. So you have to weigh those issues when you're deciding to appeal. Now we're talking about FINRA respondents going from the NAC to the SEC. 82% of the appeals were dismissed without briefing or the sanctions were affirmed, so odds are against you. And we have some other statistics, sort of one-off, dealing with certain respondents. Going to the Court of Appeals, 0 for 5. The odds are pretty tough once you get to that level. SEC side, going from the ALJ to the full commission, 29% are successful in getting the proceedings dismissed. So those odds aren't bad. Sanctions are decreased about 14% of the time, increased 43% of the time. So again, you have to be careful because you have to realize that during the appeal, the sanctions might turn out to be worse. Timing of litigation, just when I thought I was out, they pull me back in. The issue here is that litigation takes a while. We won't go into all the statistics, but on both sides, FINRA and SEC, it takes about a year from the issuance of a complaint until you get a decision. And for individual respondents, you can keep working during that time period. Similarly, if you appeal to the next level, to the SEC on the FINRA side, or to the full commission on the ALJ side, again, the suspension or sanction or whatever it is held in abeyance. So you can continue to work, you can continue serving your clients, you can continue to make money while the case is being appealed. Case study, never hurt your enemies, it affects your judgment. And this issue is it sometimes pays to litigate. This case involves American funds. It deals with directed brokerage, and I'm not going to get into the details, but there were about 20 firms, including some of my clients, that settled $50 million. FINRA said this conduct is wrong. Most firms ended up saying, fine, we disagree, but we're going to pay a sanction. American funds ended up litigating. The staff sought $98 million at the hearing. The hearing panel awarded $5 million. It agreed that there was an industry practice, but nonetheless, they thought that American funds was negligent. They appealed to the NAC 2 years later. The NAC affirmed it. They appealed to the SEC, and that decision was in June 2011. And finally, justice was served, 2-to-1 decision. They said, no, it's basically rulemaking by enforcement. You couldn't have known that this conduct was wrong, and they dismissed the proceeding. It probably cost American funds millions of dollars, but they got justice ultimately. Conclusion, if not, it's all out war, we go to the mattresses. And the bottom line message is it sometimes makes sense to litigate, and you have to know what the process is about in order to either negotiate a good settlement or in order to litigate.